landlord-tenant matter 316800-22 MY. Let's introduce each other. We start with plaintiff first, and then go to petitioner first, and then we go to the respondent. After the introduction, we will go to the movement of the motion first. The movement of the motion shall tell the court why this court should grant your motion and what grant. We will go then to the opposing party. The opposing party will tell the court why this court should deny the motion and what grant. If there's any cross motion, please goes there as well. Thank you.
Earl Williams, good morning again. Earl Williams, 20 East 3rd Street, Mount Vernon, New York, 10550, appearing for the petitioner in the law office of Jackson 1.
Good morning.
Good morning, Your Honor. My name is Arniotes Calakos from the law office of Arniotes Calakos, PLLC, located at 7206 Fifth Avenue, Brooklyn, New York, 11209, and I am appearing for Mr JeanBaptiste, the respondent.
We also have two additional third parties here. We have Mr. Benavides and we have Mr. JeanBaptiste.
Raphael, introduce yourself.
What's that?
Mr. Williams, I cannot hear you.
No, I said introduce yourself. Tell me what your name.
For whatever reason, my volume is not optimal.
I can't see anybody, but
Introduce yourself, Raphael.
Mr. Williams?
I'm unable to see anybody at this point.
And Mr. Williams, can you hear me?
Yes, everybody here.
Okay, perfect. Okay, good.
So, Mr. Benavides, who are you?
I am the landlord's representative.
What's that?
The landlord's representative.
So, you're the landlord representative.
Yes, ma'am.
Is that for Aleppo LLC?
Yeah, Aleppo LLC, that is correct.
And who is Michael JeanBaptiste?
Yes, I am the tenant.
You're the tenant.
Yes, correct.
Okay, now we're in order. Okay, so let's go to the movement of the petition. Files in the system. So your motion, who's the movement?
I am.
Okay, your motion. Since this is a motion 5, we just want to make sure we have all the documents in the system. So your motion is submitted when?
My motion was e-filed July 6th.
July 6th. Okay, notice of motion. Was that dated July 6th, 2023 as well?
Was it dated, Mr. Wilson? Yeah, it was.
Okay. Alright. And then we have the application support. And then we have the exhibit A through L. Is that your exhibit?
My exhibit is document 65.
65. Okay. What about document 52 to 62? Whose exhibit?
This is my.
Troy exhibit?
Yes.
So that's a cross motion. Okay.
Yes, you're on exit 65. I mean,
So for the respondent's motion document, that's document 45, 46, and 47, is that correct?
Yes.
All right. And then the petitioner filed the cross motion, and that's 49 all the way to 62. Is that right?
Yes.
Okay. And whose document is 63 and 64?
Not on the screen.
63 is respondent, permission and reply. 64 is petitioner's permission and reply.
Okay. All right. And then there's a 65.
Which one option?
65 is additional proof that they characterize the apartment as a residential apartment.
But that was after the submission?
Yes. We are.
Okay.
It
Okay.
wasn't weighed.
All right. So let's go to the moving first. Moving. Why you want to make that motion and why this court should grant your motion?
Okay, this proceeding was commenced in the commercial division, and my client resides in the apartment.
You mean commercial part 52, right?
Yes, commercial
Okay.
part 52. My client resides in the apartment. He has resided in the apartment, and all the initial papers that the petitioner served on my client says upstairs bedroom. So the petitioner all along acknowledges that there's a bedroom in the apartment. However, when he brings the proceeding under the guise it's a commercial proceeding and never gives my client the proper notice. So my client was residing there for over 2 years, and in 2019, the law changed, and we never received the proper notice of termination that would require him to give 90 days pursuant to the Housing Stability and Tenant Protection Act of June 14, 2019. So regardless of what the petitioner can say, he acknowledged in his own papers that the unit was used as a residential unit. And so we don't believe it's proper that it's in Part 52 at all. And part of, there's multiple reasons for that, along with the petitioner's acknowledgement, there's multiple reasons for that, including the reason why I uploaded Exhibit 65 is because even in ACRIS, you're seeing that they refer to this unit as residential. So, regardless of everything, the high standard that the law in 2019 put on landlord is that tenants should not be moved out of residential units without the proper predicate notice. And the predicate notice makes and breaks these cases.
All right, so Mr. Michael JeanBaptiste, would you be able to turn on your video?
Yeah, sure. One. Yes, ma'am. Thank you. Can you see me now?
Yes, we can see you now.
Okay, beautiful.
So, moving, respondent, you want the relief you want to seek in your motion.
No, I'm the move-in respondent. That's okay. I want the matter dismissed. He failed to serve the proper predicate notices. That makes the entire proceeding defective. And we're also seeking legal fees because my client shouldn't have had to pay legal fees.
Let's take a look to see whether you actually put your prayer in your notice of motion. You did. Order dismiss the action, legal fees. Alright. basically you want to dismiss this case and get some legal fees because the petitioner commenced this action in the wrong part. Is that right?
Yes.
Alright. Opposing party?
Yes. Your Honor, I think the facts presented by counsel, they are all incorrect. If you look at, let's go to Exhibit F.
Document number 57?
57, right. This is the lease agreement, not between the tenant there now, but the person was the real tenant. And the real tenant, it is, well, the landlord, the real tenant is Red Circle Dance Studio. And if you see on the top, it's a commercial lease agreement between Aleppo and Red Circle Dance Studio apartment. If you go to Article 5, scroll down to Article 5, Article 5 clearly tells us these premises should only be used for commercial purposes, and it's charged only used occupied by tenants for equipment in immediate staff and exclusive way, and no premises should be used during the term of the agreement for the purpose of running a business, professional trade of a dance studio. That's all. And they should not allow anybody else to be occupied the premises. Now, we can leave this, and this agreement, as I told you, it is between Aleppo and Dance Studio. Now, let us look at the sublease they are relying on, which is 57 Exhibit F.
Okay, so in terms of the sublet, did you say that the tenant shall not be able to sublet without the written consent from the landlord? Do we have that process?
No, and well, I was getting there. And, sorry, if we look at Exhibit G, the sublease 58, then the tenant attempted to give a sublease and referred to the space he was subletting as the bedroom. And we were not the ones that used the term bedroom. Your Honor, you are aware that when you want to evict someone, you have to identify the space you want them to be evicted from in a way that they understand it and they are aware. Between himself and the real tenant, they are the ones that describe in the sublease the room as a bedroom. So we have to continue referring to it as a bedroom, so you need to know where it's coming from. Now, if you look at his own list, his list is made between Daevid and sponsored Market LLC. Not him. So here it is an attempt to send company as a sublet.
Well, but it says the sponsored Market LLC and its representative.
Right, and its representative, right. But see who signed the list? Daevid O Mendivil.
Or it says not correct party.
Right. Daevid Benavides has no entitlement to the property. He has no rights, whether it's ownership rights or other things. He had there's a leasehold, but it was not built between Daevid and the built between Circle. So therefore, one, the fact that the tenant did not give his approval or his consent in writing, he had no idea that was happening. And the second thing that Daevid had no authority to give a sublease, this sublease is null and void, and it makes him a trespasser.
Okay, hold on. Councillor, hold on. Councillor, for the respondent, we will address your question later. So you will have your opportunity to rebuttal. Go ahead, petitioner.
Yes, so as such, it makes him a one, just the idea of a sublease makes him a licensing. And two, because it was a properly done, it also makes him a trespasser. He has no relationship between the landlord and himself. So therefore, the the fact that he is a licensee, the landlord, the owner of the premises, had a right under the law to give him a 10-day notice to quit the premises. And it's whether it is residential and whether it is commercial, it is the same law applies for trespassers or for licensees. Right. However, the authorities and case containers and section, the Real Property Action Law, also informs us that on section 228, that if the person came on the property through a lawful means for someone else that was on the property, like the licensee in that case, an additional 30-day notice should be served. We serve that additional 30-day notice. It is item number 3, NYSTF number 3. On it, we serve that additional.
Which document number?
3, number 3.
Number 3.
Yes. So we serve that additional 30-day notice to comply with the law, and the RCAPL again, I think it is 717, also tells us 713. So the real action property law, section 7, said any special procedures that would need to be maintained against a licensee or trespasser, we must give them 10-day notice. Wait. This is what can happen here. So whether he is residential or whether he is a commercial tenant, the required notice that he needed to be served upon him, it was the 10-day notice to quit, because he's not on the property with the consent of the landlord, and an additional 30-day notice because he was brought there by Mendivil. And we did all that. So therefore, Your Honor, for my cross motion, it is clear that my client is the owner of the premises. That's not an issue. It is clear that we gave the predicate notice, which is 10 and 30-day notice. And he has no rights, no ownership rights, no tenancy rights. As such, my client is entitled to some judgment from possession.
Okay, so in your cross motion, you want the judgment of possession, and then you want the warrant of eviction.
Yes.
What about rent? Are you seeking rent, or is the tenant current at the rent?
No, the tenant hasn't paid any rent, and we have no landlord-tenant relationship. So that's why we cannot ask rent. We do not have a figure for rent. There was never a landlord-tenant relationship between the parties. So there is not an amount of rent you can come and ask for, say, hey, but an agreement for you to pay us so much rent or this. So it's kind of impossible to set a figure for rent when there was no landlord-tenant.
Okay.
But if the court feels they can give use and occupancy from the date of the filing of that case at the rate of the 1050 as with the previous owner, we would welcome it. With the previous tenant, we can welcome it for use
So
and
when
occupancy.
did the previous tenant leave?
He left sometime in 2020.
2022, September of 2022 is when he emptied the premises.
Okay.
And then,
22.
in terms of the sublease, so-called sublease, when was that entered into?
2020.
So the original tenant was there all along, but then rented one room to the respondent since 2020.
Yes,
Is that
and
right?
the landlord, Your Honor, if I may, when the landlord found out, she was very upset, and that is the reason why she did not renew the lease for that tenant. Furthermore, if I may input something else, the DOB has inspected the premises. They even put a Vacate Order in the premises because they found a mattress in there. So in the premises, there is no kitchen, there is no bedroom, there is nothing that will make it residential. The trespasser, as Mr. Williams said, he's been sleeping on an inflatable bed, and he's been calling HPD. We went to court with HPD, and they dismissed the case because in their system and in the DOB system, this unit is a professional unit, is a commercial unit, and it's not residential. And we have copies of those vacate orders.
Counselor for petitioner, do you have the certificate of occupancy?
Yes.
Which document number?
It is document number 60.
60.
Yes.
Alright, certificate of building, certificate of occupancy, and that's for the 309 East 108th Street, apartment number 100. Is that the same apartment we are talking about?
Apartment 100 is not the apartment number. Your Honor, it's well settled case law, as my papers say, that a landlord may not remove a tenant on the grounds of an illegal occupancy. And you'll notice right off the bat that there already mentioned that there was a tenant, and that tenant's not named in this suit. So they're suing only my client. The tenant that they claim that they rented to, they're not suing. Either way, they knew he was residing there. Either way, and he residing there since 2020, and he's required to give him the proper predicate notice. It was used as a residential. They knew it was used as a residential. They knew my client in particular was using it as a residential. The client that they claimed that they rented to for commercial space, they never even sue in this suit. He should have been named. And therefore, we believe it's well settled in case law. You'll notice in my reply, I list the case law that landlord may not remove a tenant on the grounds of an illegal occupancy. So they knew it was a residential unit. They needed to put the required predicate notice, and they admit. He just said that they had the sublease since 2020. My client's been residing there since 2020, resided there for 2 full years. The 10-day notice and the claim that he's a licensee is just not reasonable. It's just not reasonable.
Illegally, Your Honor, the landlord never allowed that. That's
Okay, so Counselor for petitioner, just tell your client not to speak unless it's court instructed to do so.
Sorry,
Counselor, you are muted.
Your Honor, first of all, what comes to referring to about evicting for illegal use and all that?
Okay, before we go there, let's take a look at the certificate of occupancy.
Yes.
Alright, Counselor for landlord, what is the address for the property dispute?
Let me get it for you. Occupancy, this one.
No, not the certificate. The property address you listed in your petition. What is the address?
The address?
In your petition.
Yeah,
In your petition.
yeah, I know. Let me get the exact address. Exactly. One, 39. It's 39 East 108th Street, apartment 1C, New York, 10029.
Okay, tell me the exact address in your petition one more time, please, slowly.
It is again 309 East 108th Street. 309 East 108th Street, apartment 1C.
Apartment 1C. Could you take a look at the certificate of occupancy again, please?
Yes.
ready?
Yes.
Okay, Mr. JeanBaptiste, which floor is the apartment on?
The apartment is on the second story.
Second floor or first floor?
Again, that's the label. The apartment is located on the second story. So what it did is they mislabeled the floors. So there is 2 stories, and my apartment 1C is located on the second story. And I also have the DOB floor plan that prove that.
And the apartment, you cannot see it mislabeled. It's on the first floor, and you'll see there are 60 units, and they're all professional office. If you look at the occupants.
Yeah, if you look very simply at document number 65, and that's why I uploaded it, ACRIS shows you the apartment 1C, and it's listed as a single residential condo unit. ACRIS, the New York City property website.
We have this typical occupancy, which gives the business which one are residential. If you see second to the 5th floors, it is residential. The first floor where your client occupy is professional offices. Okay? The mezzanine, the first floor, the mezzanine, where it's supposed to be, it is storage. There is nothing there for residential. Although
Okay, so Councilor for Petitioner, 1C is on the first floor or second floor?
First floor. They are claiming the certificate of occupancy wrongly labeled. Certificate of occupancy wrongly labeled anything. That is why it is called 1C. It is the first floor. They treat there, the certificate of occupancy treats it as the first floor. That is why it is 1C. And the first floor is professional offices on the certificate of occupancy. If you look at it again, there are 60 units, and they are all professional based on this, Your Honor. And number 3, Your Honor, the issue is, even if it was residential, because it's a trespasser, because it's a licensee, okay, come on a unit without the landlord's consent, this is the proper procedure to get him out done. It is still have to give him the 10-day notice to quit and give him the additional 30 days because there is no landlord-tenant relationship and he was a trespasser. That has changed how to deal with trespassers.
Okay, so Petitioner, do you have a floor plan for the apartment 1C?
Floor plan.
Yes.
I have a copy of a floor plan, Your Honor, if you need it.
Did you upload?
No, I uploaded other documents in my reply. To me, I think case law is pretty clear. This doesn't matter because case law says that they were required to give him the
Okay, do you have a floor plan? Councilor?
Yeah, you want me to upload it?
Yes, do that now.
Okay, I know. Okay.
Your Honor, if you look at Exhibit G,
Exhibit G, okay. That's the 58?
yes.
Okay. Alright.
Gives 7 1C. Unit 1C, professional unit 1C, right?
Where?
On the second page. Scroll up.
Second page. But then the document number 58 only has one page.
No, it's not. Exhibit G is
Document
61.
61? Okay.
Go to the second page. Declaration page. That's the declaration for the condominium.
Okay, declaration for the condominium. Which
Yes.
page?
And on the second page in the exhibit.
Okay. Let's take a look.
It's kind of upside down because that's how we put it. So, but you will see the units and you will see the tabs.
Professional unit. Okay.
Yes, 1C. 1C. Specifically, referring to 1C. One
Okay.
type of office.
Alright, so just we hold there until the Respondent's counselor come back, okay?
Yep.
Just hold on this page, and you will tell the respondent's attorney about this page, okay?
Yep.
Thank you.
Okay. Well, when she comes back, and then
for Respondent, did you upload the document?
Yes, I did.
Okay, before we go there, Respondent, Petitioner, would you like to present your argument in terms of the document 61? You're muted. Counselor for Respondent.
Yes, I'm back. I'm here now. Yes. Document 61 and 62. I just want to present. Well, 61 is the declaration page.
Counselor for Respondent, did you get to document 61?
No, I just got I printed the confirmation page from the upload. It's document 66, Your Honor.
That's okay.
Right.
So, Counselor, why don't you go to document number 61.
Document number 61, the construction page of the condominium.
Just confirm with the respondent whether he's there.
Yes.
I'm getting it now, yep.
Right, 32nd page. Right. Item, professional document. One. Signed that particular floor, that particular space, professional unit. That is one, and if you go to L62.
Okay, so before we go there, Chancellor from Respondent, did you follow the petitioner?
I don't see that. I don't really. I mean, I can see what he's referring to, but I don't think this is relevant if the use was not what it was supposed to be. I don't think it's relevant.
Okay, so before we go there,
My document actually shows that it has a living space, it has a living room. So I have a contrary document filed with the building department. I have a contrary document filed in ACRIS.
All right.
This is an internal document. It could have been, I don't even see the date of February 1987. It could have been updated.
Okay.
I don't know. How are we certifying this document, Your Honor?
Well, Your Honor, that is how we can solve it now to go to 62, where if you think this one is internal, this one is from the Department of Building. Your client filed case for violations against my client while this case was going on. The date of occurrence, February 24, 2023, and when they came to the unit, this is probably reading the violation details.
where?
If you see the first set of things, you'll see the summons, you'll see the date of occurrence and the date, you'll see warning, you go there, you see cure date, and then you will see infraction code, and then you see violation.
Okay, just read that out.
Right.
Here.
Occupancy contrary to that allowed by the certificate of occupancy, COO. Observe at first floor apartment 1C has full height partition installed in mezzanine, creating a bedroom and storage room at first floor is occupied or arranged as a bedroom. Certificate of occupancy indicates mezzanine as storage, and permit number 122845289 with construction sign off dated 12/70/23 as storage. Vacate issue apartment 1C. Remedy discontinue illegal occupancy or amend the certificate of occupancy. Discontinue illegal use. So they are saying they discontinue the market because they could not do anything for the tenant because it's not a residential property. And they said the only thing that can happen, we have to amend the certificate of occupancy to allow for residential use. Otherwise, we have to discontinue the illegal use. So in the Department of Buildings, in all the records, they cannot find anywhere this room can be identified as a residential unit. Your Honor. Nowhere. And this is the Department of Buildings, they have all records concerning those things. So it is not the condominium that they are getting document, but this is the Department of Buildings. The violation he called and asked them to come in against my client, and he turned against him, and they said, hey, no, this is not illegal use, you're not supposed to be there. The certificate of occupancy and everything shows this location where you are, it is not residential. And there's nothing that we can say or bring to spin that can change it from this commercial entity for which it is to a residential amenity.
Okay, thank you very much. So the issue now here is that according to the building department documents, is the professional space 1C. the respondent's argument is that the petitioner knows that the respondent lives there as a residential, whether the petitioner needs to follow the predicate notice requirement, right, as if it's a residential space. That's a legal issue, right? So the factor issue is clear now. The factor issue is that this is a professional space. However, respondent lives over there as if it's a residential. The argument here from the respondent, the law, actually, the first law is that the issue as a matter of law, first, whether under this situation the landlord is still required to follow the predicate notice as if it's a residential place. That's the first law issue. The second issue is that where this matter should be commenced, because it's a professional space and the respondent lives over there, however, as a residential. So those are the two issues, right?
Can I settle that legal issue, Your Honor?
Okay.
Your Honor, one, if you look at this sublease, as I said, he signed this sublease as representative of his company. So he gave no indication that he was going to live there. He rented out as a representative of his company.
But he's not named in the suit.
No, his company. I say he rented out as a representative of his company. So both his company and then the suit. My client is looking for possession. The other people, the other company, or whatever they call their name, they were not in the property at the time my client filed. They had left. And my client only wants possession. He's the only one holding up possession now. So let me finish my submission. Yeah, so Your Honor, one, there was no running back. There was no kitchen. Okay? There was nothing that could make this place an apartment or a living space habitable under our laws. In terms of a warranty of habitability, there was nothing there. Otherwise, he could have taken my client to task for warranty of habitability, because no stove, no gas, no this, nothing to cook, nothing to wash, nothing, no bathroom, nothing. This is the thing that makes the place a residential unit. That's none of them. So if you rent someone an office space and the person bringing a bed and sleeps there, it doesn't change for a residential unit.
Your Honor, they had knowledge. He was there for 2 years before the action was commenced. The person prior knew that it was being used that way. Doesn't change the predicate notice required. It's well settled law. Please see in the matter of K&G Company versus Reyes, 52 miscellaneous 2D 606, 625 West End versus Johnson, Jason Howard, 2001 WL 168 2615. They're all in my affirmation and opposition. And you'll also notice for other places, for example, my exhibit C with my reply, which I believe is in the same document number 63. Con Edison is servicing the unit as a residential unit. In addition, the floor plan that I uploaded shows it as a residential unit. So if there's a discrepancy, I think you have to err in light. It's most favorable to the tenant and the law, quite frankly. Appellate law case saying that a landlord may not remove tenants on the basis of a ground of illegal occupancy.
Your Honor, I have to state that those cases were determined in accordance with Section 52, Subsection Division of the New York City Rent, Eviction and Rehabilitation Regulations. It is something totally different. All these buildings were rent regulated because it is already taxation program because this is totally different when you are a tenant living in a place and now they are violation, they're able to go out because of the violence. They said they will not allow the half of the building, the majority of properties you can see, they will all, this is under section 52, subsection C of the New York City Eviction Rehabilitation Regulation.
Mr. Williams,
under this law, well, read the process, it's not telling you, you read the laws, I mean, so I'm saying it's a totally different fact scenario here. And in any event, as I said, Your Honor, even if it was a residential building, the fact that it was a trespasser, the fact that it was a licensee, he is only entitled under real property action law. Your Honor, we can go there if you want me to read this section for you, Your Honor, it was not amended. We can go under real property action law. Your Honor, I'm going to read that section for you.
Your Honor, if I might,
Because that section was not amended. It was never amended. It tells us all putting licenses and it tells us.
Trespasser for respondent, I'm muted you, so I will let the petitioner to finish.
Yes. Your Honor, real property action and proceeding law, section 713, subsection 7. It says that the statutory provision creating the summary licenses and proceedings provide a special proceeding may be maintained on this article after tenant notice to quit has been served upon the respondent in a manner prescribed in section 735 upon the following grounds. And they see proofreader versus proofreader. So the case. And they define what a licensee is in the case. A licensee is defined as one who enters upon or occupies land by permission expressed or implied of the owner under a personal revocable, non-assignable privilege from owner without possessing any interest in the property, who becomes a trespasser upon revocation of the permission or privilege. In this case, my client will fall in that category. So
Okay, so Trespasser for tenant, that's good. Respondent, please unmute yourself. So respondent, you said the company was not named. Which company did you refer to?
the company that had the sublease that gave it to my client.
So you said they should name the original tenant?
Yep.
Why is that?
Because if he has his right under that tenant, whether or not that he got the landlord's consent is frankly, according to when my tenant got the sublease, he thought he got the landlord's consent, and he's always been residing there. There was never a time that he used the property solely as a commercial space. He always resided there. From the first time in 2020, he had a bed in that apartment, and that's where he resided.
Okay. So now we understand the issue here now, and thank you very much. We will issue a decision. Thank you very much.
Thank you. Thank
Okay,
you.
take care. Bye-bye.
Be well. Be well.
You too. Thanks.